So the criminal process in Pennsylvania is really broken down into 5 different categories. The first category is known as the preliminary arraignment. That is when an offender is charged with a crime, taken before a magistrate judge, where bail is set and the charges are read to that person, and they're processed or booked at that stage. After that process is the preliminary hearing. The preliminary hearing is the first opportunity for the defense to test the state's case against him or her. What that consists of is the Commonwealth putting forth evidence that would be considered prima facie evidence that a crime has been committed and that the person charged is more likely than not the one who committed that crime. It is not trial. It is not proof beyond a reasonable doubt. It is really just a probable cause hearing. It's very important to have an attorney before that preliminary hearing because there are some important rights that an offender is afforded at the preliminary hearing. Once the preliminary hearing is done and if the case moves forward to trial, the next process is called formal arraignment. That takes place in the county court of whatever county the offense has taken place. After that, there are certain rights that the defendant has, a right to informal discovery, a right to a bill of particulars, pretrial motions can be filed within that time frame. And then the next step in the process is what's called the pretrial conference. In between that formal arraignment and pretrial conference, the offender and his or her counsel should have the government's entire case at their disposal to determine what the next step should be. So at the pretrial conference, the defendant is telling the judge whether there's a plea agreement in place or whether the case is heading toward trial. If the case heads towards trial, most of the time that would consist of a jury. Trial would be had. The jury would come back with a verdict. If the verdict is not guilty, that ends the proceedings. If the jury comes back with a guilty finding, a sentencing is then scheduled by the judge, which can be 90 days after the trial concludes. It's very important to have an attorney throughout that entire process. And what I tell people is the earlier you get that attorney on board, the better your chances of getting the best possible outcome.